In today's video, I will be discussing about Environmental Relief Fund Scheme. The Environmental Relief Fund Scheme was established under the Public Liability Act 1991 to provide immediate relief to victims of accidents involving hazardous substances, founding on the principle of no-fault liability and in response to the Supreme Court of India pronouncements on absolute ability in MC Mehta vs. Union of India 1987, the PLIA requires industries dealing with hazardous substances to subscribe compulsorily to public liability insurance. Apart from the contributions from hazardous industries that opt for insurance under the PLIA, the ERF consists of compensation awarded by the National Green Tribunal for damage to the environment under Section 24 of the NGT Act 2010. What is the need of Environmental Relief Fund? On 29 March 1985, following the Bhopal gas tragedy of December 2, 1984, the Processing of Claims Act 1985 was passed by the Government of India for the speedy disposal of claims arising out of or connected with the Bhopal gas leak disaster. The act was challenged in the Supreme Court for its constitutional validity. Challenges of Environmental Relief Fund. The NGT has slammed the Ministry of Environment and Forest for non-utilization of over Rs 800 crore meant towards the Environment Relief Fund for victims of accidents in the process of handling hazardous substances. The UPA government notified the Environmental Relief Fund in 2008, under which the United India Insurance Company Limited was appointed the fund manager for the administering and managing the fund. The fund manager is responsible for investing the amount in the fund, making claim settlements as per the collector's order, and maintaining account statements. These account statements, along with the audit reports, are to be submitted annually to the Ministry of Environment, Forest and Climate Change. The fund is borne out by the non-fault liability principle, as it compels industry owners to compensate victims of the hazardous substances even if no responsibility can be attributed to the owner. It is also the spine of sustainability, as NGT can award damages under the polluter pay principle to ensure the environmental concerns are not traded off in the name of development. Therefore, the money in the fund is intended to support the recovery of the damages by the victim and the restoration of the environment to undo industrial or urban damage. However, in the nearly 30 years of its existence, it has become doubtful if the fund has been achieving its purpose, as accounts of underutilization and indifference by the authorities keep surfacing. The environmental jurisprudence in the country has evolved by the sympathetic to the environmental costs of the development. It has attended to the victims and gone beyond repression to award punitive damages. However, the law can be only so much in the books if the relief is not reaching the victim and the environment not being actively restored. Right from the central government to the local collector, the authorities need to be held accountable for their inaction. Attention needs to be drawn to the effective monitoring of large volumes of public money lying untouched in the fund. Thank you so much.